Yes, Mr. Crane.
My Lords, we just looked briefly at Dalla, Diag, Human and the Czech Republic.
Yes.
I hope I can just deal with, without going to the authority, what had happened in that case, to remind the court, was that there was a Czech arbitration award against the Czech Republic, but an Austrian Supreme Court ruling had been given to the effect that the award was not binding on the Czech Republic. And the question then arose in this jurisdiction.
So the Austrian court was an enforcement court, not a seat.
Exactly. And a question arose in enforcement proceedings here as to whether the Austrian Supreme Court ruling raised an issue estoppel in favour of the state. The argument on behalf of the award claimant in that case was that issue estoppel has no place at all in enforcement proceedings. And that's paragraphs, I won't ask you to go to it now, but it's paragraphs 55 to 57 of the judgment. I should have given you the reference, which is in Authorities Bundle A, tab 11, and it's the report starts at page 358.
The paragraphs were
55 to 57. And that argument was rejected in paragraphs 58 and 59. Pages 384 and 385. The relevant passage is quoted in the judgment at first instance in this case. We entirely accept that it was not a decision against a state which was seeking to uphold state immunity in face of an adverse ruling, so it doesn't get us very far, but it shows that issue estoppel has a life in enforcement proceedings. In the context of enforcement proceedings against a state, albeit, as I say, we fully acknowledge that the point was being taken for the state rather than against the state in that case. But more importantly is the case that my learned friend mentioned, which is India and Deutsche Telekom, which was decided, I think, shortly after the judgment at first instance in this case. And that is, we can look at it in a moment, but it may be helpful if I just indicate to you what we suggest we get from that decision. It's, as I suspect one can infer from the intervention this morning, you're familiar with it. It's a Singapore Court of Appeal judgment where the court included Lord Mance. What had happened was that Deutsche Telekom had obtained an arbitration award against India in Switzerland. India had applied unsuccessfully in Switzerland to set aside the award on the ground that the tribunal lacked jurisdiction. Deutsche Telekom then obtained ex parte permission to enforce in Singapore, and India applied unsuccessfully to set aside that permission, and having lost it then appealed. The key thrust of India's argument was based on state immunity, and that is apparent from paragraph 38 of the judgment, which is at page 1627 in the authorities bundle. The key thrust of Deutsche Telekom's response was based on issue estoppel, which is apparent from paragraph 43 of the judgment. And I don't propose to read to you what it said. So if I didn't give the bundle reference, I see at least one of you got it already. It's a bundle D of the authorities at tab 45. And if one just turns the pages, starting at page 1637, you'll see 3/4 of the way down page 1637 is a bold heading, "Does transnational issue estoppel and or the primacy principle apply in the context of international commercial arbitration when an issue decided by a seat court is subsequently raised again before an enforcement court?" And you'll see, if we just flick through paragraphs 63 onwards, the approach taken first of all in relation to the question whether a domestic judgment gives rise to issue estoppel is touched on by reference to English case law, the Senna. And then paragraph 64, same test applied with some modifications in the context of transnational issue estoppel against non-state parties, this is. And then we go on to a statutory equivalent to section 31 of the Civil Jurisdiction and Judgments Act, which is touched on in paragraph 65. Over the page, paragraph 67, we get the rationale for issue estoppel expressed in exactly the same kind of language as one sees in this jurisdiction. And ultimately, having walked through the law with the building blocks, as I say, that essentially reflects the same approach as in England, and you'll see references to Diag Human at paragraph 81. One gets to paragraph 96 at the bottom of page 1652, and the italicized headline, the doctrine of transnational issue estoppel should be applied when contemplating the effects to be given to a seat court's decision. The next couple of pages are sidelined. I'm not proposing to read it all to you, but could I just draw to your attention one particular feature of the court's reasoning? In paragraph 97, about 2/3, 3/4 of the way down, well, actually pick it up just over half in, it follows that the doctrine of transnational issue estoppel will apply in the arbitral context as part of the residual domestic law applicable in setting aside or enforcement proceedings. This is especially so because the International Arbitration Act is silent on this issue, and what is not governed by it must necessarily be governed by the other rules of domestic law. And that, in our submission, has resonance with our submission in relation to the State Immunity Act, which is silent as to either the procedures or the substantive law that is to be applied in deciding whether state immunity exists or whether one of the exceptions applies. And therefore, since the State Immunity Act is itself silent and doesn't expressly preclude reliance on this issue estoppel, we say the English court applies the general law, and a similar approach was taken in that case.
Does the report, which is referenced, throw any further light on this, or does it just go no further than what is said there?
I will have to find out whether somebody more industrious than I has read the report before I answer that question. But I don't know. I'll find out. But the significance, self-evidently, you're not in any way bound by what a Singapore Court of Appeal said. But this is a decision of another jurisdiction with dealing with an investor claim against a state under an international investment treaty. And where the basis of the State Immunity Act is customary international law, then decisions of the Singapore Court of Appeal, in our submission, acquire a particular significance insofar as they are evidence of what customary international law is. And my learned friend's point is simply that the argument he is running wasn't run in that case, and that is factually true. There is an absence of express consideration of that point. You take from that what you will. On the one hand, you can say, well, it isn't directly authority that proves that he is wrong. But the very fact that it didn't seem to occur to any of the counsel involved or the highly experienced tribunal that there was a point here rather suggests that there isn't.
And the tribunal was itself multinational.
The tribunal itself is multinational, and we have checked. The Singapore State Immunity Act has exactly the same provision as Section 1.2 of
I think
our
it's quoted in paragraph 38.
Oh, well, I'm grateful, yes. It has the obligation to consider the question of immunity of its own motion.
Yeah, 38 says that section 3.1 provides a state's immune from jurisdiction of the court of Singapore except as provided in the following provisions, and section 11 provides for an exception where a state's agreed in writing to submit a dispute to arbitration. So the material parts are the same.
Yes.
And apart from the Singapore judges, there's a former Chief Justice of Australia plus a former Supreme Court Justice.
Indeed so. Indeed so. The only other authority that we may mention, I've touched on it briefly, is Zhongshan and Nigeria, which Your Lordships may remember Her Ladyship mentioned in her judgment in the court below. It's one of her own decisions, and it was a case in which she refused relief from sanction where Nigeria had repeatedly failed to comply with procedural directions in the course of its application to set aside the permission to enforce in that case. Her Ladyship said in the judgment below, paragraph 38 of the judgment below, that the case was dealing with a very different situation, but nevertheless, in our submission, it does illustrate, and I think I've probably made the point already, it does illustrate the fact that by a number of different means, it is the case that a foreign state can be precluded from advancing its arguments on state immunity in that situation by failure to comply with English procedural directions. It is difficult to square that outcome with my learned friend's argument that the English court has to decide de novo on the merits. Otherwise, it is at risk of being in breach of its international obligations.
Yeah, well, I mean, the submission on the application to reopen the refusal of permission, which we've got in tab 42.
Yes.
The submission for Nigeria bears a striking resemblance to Mr. Flynn's submission.
Indeed so.
And that's rejected at paras 31 and 32.
Well, I'm grateful, my lord, and I, in that case, don't need to turn it up to labour that point. No, I don't. I'm grateful. So I
It may
can
not
move.
matter, but is as a refusal of permission to appeal, is it citable?
Ooh. Technically, I suspect your lordship may well be correct in asking the question, because I think the answer may, in fact, be no. But since it is the appendix to a case that was cited in the court below and mentioned in the judgment, it is at least illuminating to know what the outcome was. There is one other thought that we just thought that it may fit in here, which is my learned friend, as you know, has cited the London steamship case in support of the proposition that state immunity has to be decided as a preliminary issue, and it has to be decided definitively, not just on an interlocutory basis. We just wanted to go back to that case because it provides another illustration of the court applying the general law in deciding whether or not state immunity applies. So it's in Authorities Bundle B at tab 22. And just to remind the court, I know Lord Justice Mayles will be familiar with it, so this is the vessel that breaks up. It creates a great spillage, pollution damage, and civil proceedings are brought by the Spanish government in Spain against the insurers, because under Spanish law there is provision for direct liability of the insurers. But the insurance contract between the vessel owner and the insurers included a London arbitration clause. And the insurer brought arbitration proceedings in this jurisdiction asserting the right to arbitrate. And it's won. And it won that arbitration. And the insurer then issued court proceedings here, seeking to enforce the benefit of that award in this jurisdiction. And in order to do that, it needed permission to serve out, which it got. And the Spanish government then sought to set aside the order granting permission to serve out on the basis of state immunity. And sorry, it's a slightly long introduction, but it just helps because this then makes the point. The insurer's response was to say, the insurer's response to Spain's claim to state immunity was to say that by relying on the insurance contract in the civil proceedings in Spain, the Spanish government must be treated as having agreed to be bound by the arbitration clause in the insurance contract on the basis of the conditional benefit principle, which is expressed, and if we can actually pick up the judgment now, at page 909. Yes, 909, paragraph, we see section 9 applied to the section 18 application, and you get section 9 of the State Immunity Act set out there. The issue, paragraph 61, the issue is whether Spain has agreed in writing to submit to arbitration the dispute in respect of the arbitration claim. And then there's a whole brick of case law cited. But if we just pick it up at the very top of page 910, in the first line, in summary, a third party to a contract containing an arbitration clause who claims a right under such contract, whether by assignment or statutory entitlement, takes that right subject to the arbitration clause, which regulates the means by which the transferred right is to be enforced. And then some case law is cited. The obligation to arbitrate the dispute relating to the asserted claim is an equitable obligation imposed by the conditional benefit principle. And ultimately, what the court decided was that Spain was bound by the conditional benefit principle, and it was therefore deemed to have agreed to arbitrate for the purpose of section 9. And you see that conclusion. The discussion occupies the following 3 pages. The conclusion is reached at paragraph 69. So what we say about this, slightly long lead up to it, but what we say is that it provides another helpful illustration of the court applying the general law in deciding whether a claim to state immunity survives or whether an exception exists. And the fact that Spain was a sovereign state made no difference to the application of the conditional benefit principle. And we say, of course, it's not dealing with issue estoppel in any way, but we say it is another illuminating illustration of the way the court has done exactly what Mrs. Justice Cockerill said should be done in this case, which is that absent any express provision in the State Immunity Act as to how the court sets about making a decision as to whether immunity exists or whether an exception applies, in the absence of express provision, the court applies the general law. In our case, the relevance of that is obviously that the general law includes issue estoppel.
Can you say that conditional benefit is not quite the same as estoppel, but it is a kind of deeming, or is that pushing the case too far?
Well, no, it absolutely is. Yes, yes, yes. I mean, they're not, you know, they're not siblings, but they're cousins. So we just wanted to point that out. The other thing is that there has been subsequent litigation, and we've got some other decisions here, which are just before that. Tabs 20 and 21 contain further decisions in relation. I don't want to go to those because they are very long judgments and they deal only tangentially with the point, but it is worth noting that there is a later Court of Appeal judgment. It's the one at tab 20, page 709, And the only reason to take note of that is that although on the facts, the Court of Appeal in that case decided that no estoppel arose on the basis of an earlier judgment given by Mr. Justice Hamblin, as he then was, in earlier Section 66 proceedings. All we can say is that absolutely nothing was said by the Court of Appeal in that case to suggest that it would have been an absolute answer to any claim to issue estoppel based on an earlier judgment, that the issue of estoppel was sought to be raised against a sovereign state.
Well, there's no issue estoppel according to the December 2024 judgment because the issues were not the same.
Exactly, yeah, yeah. But if there had been an anterior argument that you can't even raise an issue of estoppel, that would have been a prior point to have taken. So we simply point that out at paragraphs 161 to 164, which is at page 747. I don't ask you to read it now, and as I say, it doesn't advance the argument enormously. So those are the indicative authorities, none of which is against us, none of which is directly in favour, but all of which are directly in the sense of binding authority on this court. In our submission, they are all entirely consistent with the argument that we're advancing, and in particular with the decision in the London Steamship and the India and Deutsche Telekom. They really cannot be squared with the approach that my learned friend would wish to urge on you. One other thread, still under this same, the first argument that there is this absolute rule against giving effect to issue estoppel in the context of a claim to state immunity. One other thread that the written argument seeks to work with is this idea that the State Immunity Act comprises an exclusive code and that, again, we say with a leap of illogic, therefore the Russian Federation says there is no room for issue estoppel. The argument is that since the State Immunity Act is an exclusive code, it is illegitimate to apply common law rules such as issue estoppel in defiance of the statutory code. Essentially, we have three answers which are outlined in, I won't ask you to turn it up, but we've outlined them in paragraphs 9 to 12 of our skeleton, if you want to go back to it. But essentially, the three answers we give are these. First, the State Immunity Act is not an exclusive code in a relevant sense. It is an exclusive code insofar as it defines the substantive availability of state immunity and the circumstances in which an exception can arise. So it is dealing with the jurisdiction question. It is not an exclusive code because it says nothing about how the court sets about deciding whether state immunity applies or an exception applies. None of the authorities on which my learned friend relies supports the approach that he would wish to take. There are just two cases I wanted to mention here, three. The first is Allcombe and Columbia. I don't ask you to go to it, but for your note, Allcombe and Columbia is in the authorities bundle A, tab 3, and learned friend Skeleton seeks to rely on a passage at page 600, which is, I don't ask you to go to now, but page 600 of the report is page 54 of the bundle. What the court said simply is that the State Immunity Act purports, I'm not sure why he uses the word, but it does, purports to deal comprehensively with the jurisdiction of courts of law in the United Kingdom. Well, indeed it does. But that doesn't address the question in this appeal. The The second case my learned friend cites is on analysis very squarely against him. NML and Argentina is in Authorities Bundle C at tab 25, starting at page 973. And what had happened in that case was that the Argentine government had issued bonds which were subject to an express submission to the jurisdiction of the New York courts. A claim was brought in New York on the bonds, a New York judgment was obtained, and enforcement was sought here. There were two relevant issues for our purposes. Well, there's actually only one relevant one, but it's significant to note the one that wasn't relevant. Issue one was whether the proceedings that were brought in this jurisdiction to enforce the New York judgment fell within the commercial transactions exception in Section 3 of the State Immunity Act by virtue of the fact that the New York judgment had been granted in relation to commercial transactions. So the underlying transactions were commercial, but what was being sought to be enforced in this jurisdiction was the New York judgment. On that point, the Supreme Court was split. The majority took the view that what was being enforced was a judgment and the Section 3 exception didn't apply. That is a bit of history just so that when we look at it, you understand in relation to what various things are being said in the judgment. The second issue, issue 2, was Argentina's argument that the State Immunity Act represents a comprehensive code and therefore, so the argument went, enforcement under the Civil Jurisdiction and Judgments Act, Section 31, was only possible in relation to a foreign judgment which also satisfied one of the exceptions to state immunity in sections 2 to 11 of the State Immunity Act. And that was precisely the argument that the unanimous Supreme Court rejected. So we just picked that up. If you've got, so the judgment authorities bundle C, tab 25, and you'll see that issue 2 is dealt with in the head notes at paragraph 2, so that's page 974. Where the ratio is summarized as being allowing the appeal that Section 31 of the 1982 Act was not an additional barrier to be crossed before enforcing a foreign judgment against the state, but was an alternative scheme for restricting state immunity in the case of foreign judgments. That the effect of Section 31(1), which accorded with its natural meaning, was that a foreign judgment against a foreign state would be recognised and enforceable in England if the normal conditions for recognition and enforcement of judgments were fulfilled, and the foreign state would not have been entitled to state immunity if the foreign proceedings had been brought in the United Kingdom. That the claim for the enforcement of the New York judgment satisfied those conditions, and that accordingly the defendant was excluded from state immunity by virtue of Section 31(1). So what one gets from this decision is that the State Immunity Act is not an exclusive code in relation to state immunity, because the Civil Jurisdiction and Judgments Act, Section 31, makes a bespoke provision which requires recognition and enforcement of foreign judgments against a state if the conditions in Section 31 are satisfied.
I suppose you would say that even as simple a matter as the fact that the existence of the exceptions has to be proved on the balance of probability shows that the Act is not exhaustive. It doesn't say anything about the standard of proof, which might have been
no.
beyond reasonable doubt. So
Exactly.
you have to invoke
Yes.
the general law.
Absolutely. Absolutely. So the decision on that point, that issue 2, it appears at page 993, and I won't attempt to read it, but you'll see the italicized heading at the top of page 993, issue 2. Is Argentina prevented from claiming state immunity in respect of the present proceedings by section 31? That issue covers the next 3 pages. I would simply emphasize, while I'm on my feet, 2 short passages. In paragraph 47, just below letter H on that first page, a couple of lines below letter H, there's a sentence in the beginning of the line beginning thus. So far as foreign judgments are concerned, section 31 both reflects and in part replaces the exemptions from immunity contained in the 1978 Act. And then over the page at letter B, far from providing an additional hurdle, and this is what was tracked in the head note, far from providing an additional hurdle that the claimant has to cross before enforcing a foreign judgment against a state, section 31 provides an alternative scheme for restricting state immunity in the case of foreign judgments. Now, as I say, we rely strongly on that because Mrs. Justice Cockerill has decided that the requirements of section 31 are satisfied in relation to the Dutch judgments. And as a result, the English court is bound under section 31 to recognise the Dutch judgments. And we ask the court to do that by giving them issue estoppel effect. The passage on which Marlene, just so that you've got that while we're in this judgment, the passage that my learned friend's skeleton relies on in the judgment of Lord Phillips is at page 988. I just would observe 2 things about this. So, sorry, just context. The passage that Marlene Friend's skeleton relies on is the passage talking about the State Immunity Act providing a comprehensive code. 2 observations about that.
Sorry, you're looking at paragraph?
Paragraph 26.
26, yeah.
Where Lord Phillips says, I agree with the Court of Appeal that the expression relating to is capable of bearing a broader or narrower meaning as the context requires. So we're talking about the section 3 exception here. Because this is, just to put, to put it in context, if you look back at page 986, you'll see that the heading is issue 1. This is the point on which the Supreme Court was divided, and in fact Lord Phillips happens to have been in the minority. I don't think it affects the validity of what he says, but what he says at paragraph 26 is, I agree with the Court of Appeal that the expression relating to is capable of bearing a broader or narrower meaning as the context requires. I disagree, however, with their conclusion as to the relevant contexts. Sections 1 to 11 of the 1978 Act are a comprehensive statement of the scope of state immunity under the law of the United Kingdom. Now, Marlene Friend latches onto that sentence in isolation in support of the proposition that the State Immunity Act provides a code which allows of no admission of issue estoppel. The points we would simply make in answer is that His Lordship is plainly not addressing that. He is not talking about the means by which a decision is taken under sections 2 to 11. he's talking about the definition of what the exceptions are. And secondly, he cannot, in fact, have meant what he appears to say, namely that the State Immunity Act is an absolutely exhaustive code, because he signed up to the majority view that the Civil Jurisdiction and Judgments Act provides another route for defeating a claim to state immunity. But the main point is simply that, as I say, whether you choose to call the State Immunity Act a comprehensive code of the definitional elements of the scope of immunity and the scope of the exceptions, even that doesn't answer the question in this appeal, which is how you set about establishing whether the exceptions apply. And then finally, so that is all I wanted to say on NML and Argentina. My learned friend, in his skeleton, this is paragraph 38 of the original skeleton. The last case relied on in this comprehensive code line of argument is Al-Adsani and Kuwait. My learned friend, I don't think, went to that in his oral submissions, but I'll just better give you our answer so you don't have it unanswered. Al-Adsani and Kuwait is in Authority Bundle A, tab 2 at page 18. And the point in that case was it was a claim against Kuwaiti officials for alleged torture. And the question was raised whether torture is such an egregious breach of jus cogens that it must in itself constitute another exception to state immunity. And what the court said in that case is, no, it doesn't, because the State Immunity Act defines the exceptions to state immunity. That doesn't help you answer the question at all, because we are not trying to establish a new exception to state immunity. The argument in front of you is as to the process by which the existence of an admitted exception is determined. So, as I say, the first answer, still under this heading that the State Immunity Act constitutes an exclusive code, our first answer is that the authorities on which my learned friend's argument relies do not support that. The second point in response is that in any event, my learned friend's argument in this regard actually begs the question in this appeal, because my learned friend merely assumes or asserts what he needs to prove, namely that giving effect to an issue estoppel would be inconsistent with the State Immunity Act. And with the greatest respect, there were repeated assertions of that conclusion in the course of my learned friend's oral argument, without any articulation as to why it is so. We readily accept that sections 2 to 11 of the State Immunity Act identify the exceptions, but none of them, nor section 1, says anything about how the court sets about determining whether any of those exceptions applies. My learned friend took you to the Zuzain Wittgenstein Bourbon case, where Lady Simler made some remarks which your lordship asks my learned friend to unpick about the court deciding by whatever process it saw fit. We would invite your attention back to that. It's paragraph 22 in that judgment, just for your note, and the judgment is in Authorities Bundle A at tab 10. paragraph 22, page 339. I don't ask you to go to it now, but we do submit that that is another recognition of the fact that the State Immunity Act identifies the jurisdiction, the entitlement to state immunity, and the headline points for exceptions, but it doesn't answer the question as to how the court sets about deciding whether those exceptions apply. The third response to my learned friend's argument that the State Immunity Act constitutes an exhaustive code is to say that in the circumstances of this case, we submit that the Russian Federation is palpably wrong in asserting that it would be incompatible with the State Immunity Act to give effect to an issue estoppel. I don't think I need to go to it, but the authority that my learned friend seeks to rely on is some passages in Benyon. We've got that in the authorities bundle. It's section 25.8. I don't ask you to get it out now. It's section 25.8 of Benyon, which is in authorities bundle D, tab 53, page 1185. And what it says, unsurprising, uncontentious, is that the common law cannot be allowed to operate if it would be repugnant to a statutory code. In our submission, there is no repugnancy to the State Immunity Act in giving effect to an issue estoppel. On the contrary, giving effect to an issue estoppel in relation to a foreign judgment which satisfies the requirements of Section 31 of the Civil Jurisdiction and Judgments Act is entirely congruent with the statutory code, and it would be repugnant to the code not to recognise it, because the court has to recognise it under Section 31. So that's all I wanted to say in relation to Merlin Friend's argument on the exclusive code concept. Another thread in the argument is that one can, our case, as you know, is that the Act is silent the State Immunity Act is silent on how you decide whether or not the exceptions apply. Merlin Friend's answer is that actually some of the case law does answer the question about how you set about deciding whether or not one of the exceptions applies. And he cited that Corinne Zusein-Wittgenstein case with references to balance of probabilities. And he cited the London steamship case at paragraph 54, which contains the observation that state immunity has to be determined as a preliminary issue definitively and not on an interlocutory basis. Neither of those authorities assists my learned friend at all. It is undoubtedly the case that the question of state immunity has to be decided definitively. It's not an interlocutory issue. The court has to make its mind up whether state immunity exists or not, but that simply doesn't address the question with which you are concerned, which is how does it decide that? And similarly, the fact that if there is a dispute of fact, it is decided on the balance of probabilities, that again doesn't answer the question as to whether or not state immunity has a role. The balance of probabilities is a standard of proof that can be applied to any element in the dispute. It can be applied to the satisfying or not satisfying the conditions for recognising a foreign judgment here.
You mean the question whether issue estoppel has a role, I think?
You said state immunity.
I'm so sorry. Sorry. Yes, issue estoppel. So we simply submit that those authorities touching on the question of balance of probabilities are entirely irrelevant to the issues with which you are concerned. Before finishing on Merlin Friend's first argument, his sort of high threshold point of principle, we just wanted to emphasise points as to the implications of what is being suggested. As far as we can see, if the Russian Federation's argument were to be accepted, then it's difficult to see how Zhongshan could have been decided as it was. On my learned friend's argument, a state is entitled to require the English court to decide on the merits. All of its arguments on state immunity. So on that basis, it could hold back arguments until the eve of trial. It could raise new arguments on appeal, which it hadn't run before, and say, well, you've just got to listen because you've got to make your own minds up. And it would be entitled to say that even a foreign judgment that decides something that isn't of itself determinative of state immunity, if there was, for example, foreign proceedings in which the question was simply, was the foreign state a party to a particular contract? Even that couldn't be relied on. That would have to be retried all over again in this jurisdiction in relation to a claim to state immunity. And my learned friend says, oh, well, you shouldn't worry about that sort of duplication of effort, because that's inherent in Section 67 of the Arbitration Act, where a challenge is brought in the court to an arbitral ruling on its own jurisdiction. The court hears it all over again. Indeed it does, but that's not the point here. What we are talking about is giving recognition in this jurisdiction to a court decision in another jurisdiction. And so the relationship between an arbitral tribunal making a decision on its own jurisdiction and the court, on the one hand, and the question whether the English court should recognise a foreign court judgment of competent jurisdiction between the same parties, which satisfies the requirements for issue estoppel on the basis of a foreign judgment and satisfies the requirements of Section 31 of the Civil Jurisdiction Judgment Act, are simply not comparable situations. So with the greatest respect, the Section 67 analogy does not assist my learned friend, and he is presenting the court with a stark proposal. He's right, but it would be a surprising outcome if cases we've looked at were, on his view, wrongly decided. So that's all we wanted to say on the very first and main point. The second point, going back, just remembering the structure of paragraphs 1.1, 1.2, and 1.3 of my learned friend's supplemental skeleton. The second point is that there is no decision by the English court on state immunity if effect is given to issue estoppel in relation to a foreign judgment. So I just want to address that now. And there are really two elements in the argument, and I think it's helpful to identify them and address them separately. The first is an assertion by the Russian Federation about the nature of an issue estoppel. The assertion is that where the court gives effect to an issue estoppel, it doesn't itself decide the issue in relation to which the estoppel has been invoked. That's the first element in the argument. And the second step in the argument, on that premise, the second step is that if effect is given to the issue of estoppel in this case, the English court would not be making its own decision on the Russian Federation's claim to state immunity. I just, for the avoidance of doubt, wanted to mention that my learned friend, I'm sure, in a moment of forensic humour, suggested that we agree with this. We look at paragraph 21 of his supplemental skeleton, core bundle tab 12, page 166. Paragraph 21 says, that follows from first principles as to the nature of issue estoppel. An issue estoppel binds the parties to a litigation as a substantive right and not the English court as a rule of evidence or procedure. Its effect is therefore not to dictate the determination of an issue, but to prevent it from arising in the relevant proceedings altogether. The respondents rightly accept this, noting that an issue estoppel prevents certain points from being taken on their merits before the English court. I hope the quotation that has been given there gives the lie to the assertion that we agree with my learned friend's proposition. The effect of an issue estoppel, for the avoidance of doubt, is that the court does decide the issue in respect of which the estoppel has been raised. But it does not need to decide that issue by reference to any other evidence than the judgment which gives rise to the issue estoppel. So when an issue estoppel is raised, the English court here isn't saying, I'm not going to rule on that. The English court is going to say, I can tell you what the answer is, and I am ruling on it, but I'm ruling on it by reference to the foreign judgment. So, and I hope the language of what is quoted there makes that clear.
Well, I mean, there are two slightly different points, aren't there? If you want to raise an issue estoppel based on an English judgment, then the second court will look at what the first court decided. If, on the other hand, you want to raise an issue estoppel based on a foreign judgment, it's not enough simply to have the foreign judgment.
No.
You've got to have the evidence, as the judge had, on what its effect is
Yes.
in the foreign jurisdiction.
Yes, that is entirely
So
correct.
the evidence doesn't go to the underlying question,
No.
but the evidence which the court receives does go to the status of the judgment on which reliance is being placed.
No, you're absolutely, I'm grateful, and you're absolutely right. I was going to come to that in a different moment, but I can see it logically deserves to be recognised here. So I think to some extent, just as I say, there are the two elements in the Russian Federation's argument. The first one is, if there's an issue estoppel, the court doesn't decide anything. I think to a significant extent, I've probably already answered that. My learned friend, as you know, relied on the passage in Mills and Cooper, which was read to you this morning, and my Lord Justice Lewison picked up that doesn't say what my learned friend would wish it to say. It doesn't say there is no decision on the issue. It doesn't say there is no issue to be decided. It says that there is no issue to which evidence on the merits is admissible. My learned friend Skeleton, he didn't go to this in his oral argument, but just so that you have the note, my learned friend Skeleton also cites for this proposition that there is no decision on the issue in relation to which an issue estoppel is raised. He also cites the decision of Mr. Justice Foxton, I think, in Mintz, PJSC National Bank Trust and Mintz, at paragraph 23, little Roman 1. I don't propose to go to that, but for your note, it's in Authorities Bundle C, tab 28, and paragraph 23.1 is at page 1100. It, with the greatest respect, simply does not touch on this issue at all. So neither of the authorities cited by my learned friend support his proposition. Logic doesn't support his proposition for the reasons that I hope I've already explained. The court isn't declining to take a decision. It is taking a decision in relation to the matter upon which the issue estoppel has been raised, but it is taking it by reference to a limited universe of evidence. So the first step in the Russian Federation's argument that giving effect to an issue estoppel would involve a sort of an abdication of the English court's obligation to make a decision on state immunity. The first step in its argument fails, and for that reason, the second step fails also, but we'll address that. The second step in the argument, as you'll recall, is that the Russian Federation says that giving effect to an issue of estoppel in this case, based on the Dutch judgments, would involve the English court failing to make its own decision on state immunity, even leaving out of account the point that we have just decided, we've just argued. The fact is that Mrs. Justice Cockerill did decide on state immunity. The Russian Federation may not have liked the way she set about doing it, but she did make a decision on it. That is what the preliminary issue 2 asked. Preliminary issue 1 was, can the Russian Federation have another go on the jurisdictional arguments? And preliminary issue 2 was, if they can't, should its claim to state immunity indeed be dismissed? And she answered issue 2, and she said yes. So whether the Russian Federation, as I say, likes the process by which she got to that position, she did make a decision on state immunity. So it is simply a false argument to suggest there isn't a decision on state immunity. And if one unpicks how Her Ladyship got there, the Russian Federation's argument unravels even further, because essentially there are two elements in deciding whether or not the Russian Federation's claim to state immunity survives. The first is, does the exception on its face, does the exception under Section 9 apply? Now, if one looks, it may help actually just to turn up Section 9, which is in Bundle D, tab 49. Page 1806. Where a state has agreed in writing to submit a dispute which has arisen or may arise to arbitration, the state is not immune as respects proceedings in the courts of the United Kingdom which relate to the arbitration. This section has effect subject to any contrary provision in the arbitration agreement and does not apply to any arbitration agreement between states. Now, it may, having got that open, also just be helpful to remind ourselves what the preliminary issues actually were. And they're quoted in the judgment below at paragraph 3, so that's core bundle tab 3, page 17. Issue 1, whether and to what extent the Russian Federation is, by reason of certain judgments of the Dutch courts, precluded from re-arguing the question of whether it has agreed in writing to submit to arbitration the disputes that are subject to the awards. 2, whether if the answer to issue 1 is that the Russian Federation is so precluded, the jurisdiction application ought to be dismissed forthwith. So essentially, section 1 is asking a section 9 question, and issue 2 is asking a section 1 question. But issue 1 is only asking one aspect of issues that can come up under section 9. The question that is being asked is Russia precluded from re-arguing the question whether it agreed in writing to submit the dispute to arbitration? In principle, even if it had, there might have been an argument that the proceedings here don't relate to the arbitration within section 9.1, or that there was some contrary provision in the arbitration agreement within section 9.2. So all we are pointing out is that the fact that the Dutch court judgments were conclusive on the question of Russia having agreed in writing to submit the dispute to arbitration, and that leading to a decision under section 1 that there is nothing left in the state immunity argument is simply a result of the fact that Russia chose to run in the Dutch proceedings and here identical jurisdictional arguments. The fact that in the circumstances of this case, Russia happens to have nothing to say on whether the enforcement proceedings here relate to the arbitration, and the fact that it can't run an argument for saying that there is any contrary provision in the arbitration agreement, those are facts. But they are, in principle, questions that the English court has to decide before it decides that there is no state immunity. The fact that the Dutch judgments give the only answer that is needed in this case to decide whether Section 9 applies is, as I say, simply a result of the way that Russia has run an absolutely identical jurisdictional argument in the Dutch courts and here. And indeed, it was precisely on the basis that there was an identity between the issues, the jurisdictional issues in the Dutch proceedings and here, that the stay was resisted in front of Mr. Justice Henshaw and then later Mr. Justice Butcher, because the Russian Federation at that stage was saying, well, look, the Dutch court hasn't yet
You
had
call that the wrong way around. It wasn't resisted, it was advocated.
the stay. Sorry, the lifting of the stay was resisted. I do apologise. You're quite right. I did. Yes. Russia, as you appreciate, was saying at that stage that the Dutch courts had not had their final say on the jurisdictional issues. There's a risk of inconsistent judgments if you let the English court proceed to determine, and so on. And now, paradoxically, of course, the Russian Federation is advocating for a world in which the English court has to make its own mind up about jurisdiction, hoping, no doubt, the Russian Federation would hope that the English court comes to a different view from the Dutch ones. So their position now is, in a sense, dependent on establishing inconsistent judgments with the curial seats. Otherwise, there would be no point in continuing to argue on state immunity. The point we simply wish to make in relation to Section 9 is that the court here takes the Dutch judgments, it then examines, as my Lord said, this is the point I was going to pick up, the points my Lord Justice Lewison has already made, is that the court doesn't just look at the Dutch judgments, it considers whether issue estoppel would be available if the defendant had not been a foreign state, which is what the judgment does by reference to the issues listed in paragraph 21, whether the Dutch judgments were final and conclusive, whether the Dutch judgments were raised judicata under Dutch law, and whether the then pending ruling of the Amsterdam Court of Appeal could affect finality in relation to the ruling on jurisdiction. So all of those were the issues that Her Ladyship dealt with in paragraphs 64 through to 112, effectively. She had, in the course of that, to consider, as I say, whether the issues, the jurisdictional issues in the Dutch proceedings and here were the same, and she reached the conclusion that they were, and there is no appeal against that, unsurprisingly, because she was plainly right, and as Mr. Justice Henshaw and Mr. Justice Butcher had previously said. So it is wrong in our submission to suggest that the English court isn't taking a decision on Section 9 by giving effect to an issue estoppel based on the Dutch judgments. And
just out of interest, there was a conflict of Dutch expert evidence. Was that was there oral evidence, or
no,
simply resolved on the reports?
Yeah. Yes, as I say, the English court takes its decision on Section 9, and the English court, and that's essentially preliminary issue 1 that Her Ladyship decided, and then the English court takes its decision on section 1. Does state, in the light of it, the finding as to whether or not section 9 applies, does the claim to state immunity necessarily fall? And in one sense, it doesn't sort of matter quite where analytically one fits this aspect into the analysis, but what Her Ladyship dealt with then was the exceptional circumstances question, having decided that the Dutch judgments satisfy the requirements for section 9. Satisfy the requirements for giving effect to a foreign judgment by way of issue estoppel, and satisfy the requirements of section 31 of the Civil Jurisdiction and Judgments Act. And then in paragraphs 114 through to 119 of her judgment, Her Ladyship then looked at the question of whether there are special circumstances as to why issue estoppel should not be given effect. And in that context, again, she is making a decision as to whether or not state immunity should be upheld, or whether the exception under section 9 should be allowed to stand. In our submission, for those reasons, it is impossible for the Russian Federation now plausibly to suggest that the English court, in taking the approach that it has abdicated its decision on whether state immunity applies. The only other sideline to this thread in the Russian Federation's argument is the rhetoric that was used saying, well, issue estoppel can't be used to expand the court's jurisdiction. In the greatest respect, the case law that Madeleine Defendant is looking at there is entirely irrelevant to the issue in front of you. The jurisdiction of the court is set out in the State Immunity Act. We are not trying to conjure some new exception to state immunity. We're saying the exception in section 9 applies, and in order to prove it, we're relying on the Dutch judgments. The case law, there were those various embassy employee cases where, for example, the solicitor's letter is written saying, I think embassy employees, I'll go to them in a moment, but just to remind you of the thread, the solicitor's letter is written saying, saying I think the employees will have state immunity. The State Immunity Act tells you when state immunity exists. If those employees are part of the mission under section 16, there is immunity. The solicitor's letter can't create an exemption, an exception to immunity.
But I think the argument in the Lord Justice Pill's case, I can't remember which one it was that the state had submitted to the jurisdiction, so that they weren't trying to conjure up a new exception to state immunity. They were trying to prove it by means of an estoppel.
There are two cases. It may be convenient just to go to them first. So the first one is Ahmed and the government of Saudi, the Kingdom of Saudi Arabia, which is Authorities Bundle A. Yeah,
well, that's
bundle.
it to Mr. Flynn is very weak authority, since the point was not argued, not supported, not raised in front of the Employment Tribunal or the EAT, but nonetheless he recognises a principle laid down by an earlier case. Yes, your Lordship recalls what happened here. The letter is written to the military attaché, and this is it was the other case that was arguing about submission to the jurisdiction. This case the argument was that the letter, actually it wasn't even the argument, as you pointed out, it was the tribunal itself decided that the letter itself
somehow created a jurisdiction to hear the claim.
Yes, the section relied on was section 2.2.
Yeah.
It says a state may submit after the dispute giving rise to proceedings has arisen or by a prior written agreement.
Yes. So it was, yeah, sorry, it was, yes, it was the suggestion was somehow that the solicitor's letter was a prior written agreement. If the solicitor's letter wasn't a prior written agreement, then there was no state immunity. And the fact that a representation was made couldn't create a jurisdiction that wasn't there. That was the point that's being made by Lord Justice Pill, because the hard edges of immunity and the scope of the exceptions are laid down in the Act. So writing a letter can't alter the scope of the exceptions. That's the point that's being made there. That has nothing to do with the situation in this case, because we are relying on a jurisdiction that plainly does exist under Section 9. And the question is, what is the evidential basis for satisfying the English court that that exception applies? And there are two universes of evidence. Russia's evidence will no doubt require months of trial. Ours is the Dutch judgments and the expert evidence explaining their effect under Dutch law. So giving effect to an issue estoppel based on a foreign judgment which is conclusive on the merits as between the same parties on an identity of issues has nothing to do with the point being made in Ahmed and Saudi Arabia, where what was being said was that the tribunal did not have jurisdiction and it couldn't be created by essentially by representation. Estoppel is being used in that context, probably entirely erroneously. I mean, on no view really was there any estoppel. It was just a representation was made to the employees that the solicitor thought that they'd be entitled to employment protection. The other case is the Yemen and Aziz case, which is in Authorities Bundle C, tab 31. That was the one where a solicitor purporting to act for the Yemeni government served a notice of appearance, and the Yemeni government then claimed that the notice had been served without recognising its implications. The Employment Tribunal held that the government had waived its immunity, and in the Employment Appeal Tribunal, the Yemeni government then sought to adduce new evidence and run a new argument that the solicitor had had no authority to do what he did. And that then fetched up in the Employment Appeal Tribunal allowed the new evidence, allowed the new argument to be run, and allowed the Yemeni government's appeal. That fetches up again in front of the Court of Appeal. And the 2 points that the Court of Appeal makes are first that the Employment Appeal Tribunal was entitled to allow the new evidence and the new argument. And as a matter of law, the point that matters is that essentially the Yemeni government could not have submitted to the jurisdiction if the solicitor didn't have authority. There was a dispute on the new evidence whether he did have the ambassador's authority. If he didn't have actual authority, what the court was saying is that there wasn't a submission. If there wasn't actual authority to serve the notice of appearance, then the Yemeni government had not submitted to the jurisdiction. State Immunity Act creates an exception if there has been a submission to the jurisdiction. All the court was saying is that by writing a letter without authority, the solicitor couldn't create jurisdiction that didn't exist by asserting authority. Jurisdiction can't come about through ostensible authority if in reality there is no authority. But that is simply a function of the fact that the scope of the exception under the State Immunity Act is that the government has submitted to the jurisdiction. If the government has in fact not submitted to the jurisdiction because the notice of appearance was served without actual authority, then the precondition to the exception doesn't apply.
Well, why can't that be deployed against you by saying the question under Section 9 is whether the Russian Federation has submitted, has agreed to resolution of the disputes by arbitration? Either it has, as a matter of fact, or it hasn't, and to rely on a decision of the foreign court to establish the very fact that the English court needs to decide is akin to reliance on ostensible authority to reach the conclusion that the Republic of Yemen had submitted to the jurisdiction.
Well, two answers to that.
Yep.
One is ostensible authority doesn't mean actual authority. The exception, what was attempted to be created here, was a new category of exception, namely where the government hasn't, in fact, submitted.
Is that strictly right? If somebody does something within their ostensible authority, they are treated as if it had been within their actual authority, are they not?
For what purpose? For private law rights?
Yes.
But the question and the answer here is by reference to the State Immunity Act. So if the State Immunity Act says that the exception applies where the state has submitted, then ostensible authority, a private law concept, which may bind in private law, doesn't answer the question posed by the State Immunity Act. So that's one answer to your Lordship's question. The other answer to your Lordship's question is that what we are seeking to do is to rely on an obligation by the court to give recognition to the Dutch judgments under Section 31 of the Civil Jurisdiction and Judgments Act by issue estoppel.
Yeah. I mean, I suppose you could rationalise the Republic of Yemen case by saying that essentially it's a decision on the interpretation of Section 2, so that submission means actually submitted, and derive strength from that by saying that Section 2, subsection 3, defines the limited circumstances in which a state is deemed to have been submitted.
Yes.
So that deeming by virtue of ostensible authority is not covered. But that doesn't seem to be the way that it was actually decided.
It doesn't, but that would be a coherent way of rationalising what the outcome was. And as I say, for the two reasons I've offered, we would submit that it is in a different category from giving effect to a judgment of a foreign court of competent jurisdiction, which, if this weren't a state immunity case, would be a judgment that would be given issue estoppel effect to. The last authority on this thread was Dickinson on state immunity, but that, in fact, says nothing other than to refer to the Ahmed and the Aziz cases, and can't add, doesn't purport to add to them. It says nothing more than the case law, and nothing at all about issue estoppel. So that is my learned friend's second argument. His third argument, you will recall, is that where there is, in the language of his skeleton argument, an irreconcilable tension between the public policy supporting issue estoppel and the public policy supporting state immunity, he says that the public policy supporting state immunity is more important, because it engages the United Kingdom in international obligations, and as a result, the public policy supporting issue estoppel must yield. We have two responses. I think we have two responses. There may, in fact, be different ways of saying essentially the same thing. The first is that, with respect, my learned friend's argument again begs the very question in issue, because he is assuming what he needs to prove. If we just look again at his supplementary skeleton, which captures this argument, core bundle, tab 12, page 159. You'll see he says, it follows that issue estoppel can't be taken into account in the exercise undertaken by the court under section 1.2. Contrary to the position taken by the respondents, that approach is consistent with principal state immunity and issue estoppel are both important questions of public policy. Where an English court is faced with an irreconcilable tension between the two, proper consideration of state immunity must be given priority over issue estoppel. This is properly conceived as a threshold matter. Where state immunity arises, the English court does not consider whether issue estoppel arises. Well, that self-evidently begs the question. The question is, does state immunity arise? To say where state immunity arises, the English court doesn't consider issue estoppel, begs the question in the appeal. The very question is, can issue estoppel be invoked in order to decide whether state immunity arises? So, as I say, our first argument is simply to respond that Leonard Friend's point isn't an argument at all. It is yet another assumption that he's right and an assertion of the conclusion. We entirely accept as a matter of principle that competing public policies sometimes arise, and the court somehow has to decide which one to give priority to. But my learned friend's argument here simply assumes he's already right, that issue estoppel somehow offends against the English court's obligation to make a decision under the State Immunity Act. The alternative argument that's put there is that state immunity, he said, just to finish on that paragraph, alternatively state immunity may be considered a special circumstance, militating against the application of issue estoppel as presently reflected in ground 4. But again, our submission in relation to that is that self-evidently, special circumstances can lead the court to disapply an issue estoppel that would otherwise arise. But unless you have already satisfied the court that there is some offence to the regime under the State Immunity Act, then there's no reason to do so in this case. And indeed, precisely because Section 31 of the Civil Jurisdiction and Judgments Act requires the English court to recognise the Dutch judgments, it can't possibly be said there are special circumstances which militate against giving effect to them by way of issue estoppel.
Is that where the contrast you draw in opening between cases where Section 31 is applicable, where it's not?
That may well be, yes. That
The
may well
special
be
circumstances.
yes, that may well be the world in which it has most life, yes. The second response, if it is a second response, is that, or it may just be a continuation of the same point, is that there is, on analysis, no tension between the two public policies in any event. The public policy supporting issue estoppel is the well-known public and private interest in achieving finality in litigation. The public policy supporting state immunity is to uphold customary international law by giving effect to state immunity if it exists. But there is no public policy in simply allowing a state all manner of opportunities to argue whatever points it wishes to argue in support of its case on state immunity. If state immunity does exist, and there isn't an exception, fine, my learned friend has already won. But to assert that state immunity is more important, and therefore in answering the question as to whether it exists, you have to ignore issue estoppel, is yet another non sequitur. So on the third argument, we submit that there really is nothing in it. If Milan was right on his first point, it would lead to the third argument being correct, but it isn't, and so it isn't. The residual points.
I suppose there is anyway a disconnect between state immunity in customary international law and the provisions of the State Immunity Act, because the Act does not simply enact the restrictive theory in international law. In common with a lot of jurisdictions, it sets out its own code.
Yes.
So,
indeed,
there is always the possibility that even giving effect to, giving effect or not giving effect to state immunity under the provision of the Act will not correspond with what the position would be under customary international law.
No, you're absolutely right. I'm grateful. There are just a few residual points to pick up. The first is what is listed as ground 3, which you may recall from the grounds of appeal says that Section 31 of the Civil Jurisdiction Judgments Act is not available as an overlay. To be honest, we still don't understand why, if at all, my learned friend is suggesting that Section 31 is inapplicable or somehow irrelevant. The decision that Mrs. Justice Cockerill took was that the preconditions to the application of Section 31 are all satisfied, because if the Dutch courts had been applying the rules under the State Immunity Act, the Dutch courts would have had jurisdiction to give the judgments that they did, because the Russian Federation initiated the proceedings there, which they didn't have to do. So Section 31 is satisfied. As a result, the English court is required to give effect to the Dutch judgments. The fact that we are inviting the court here to give effect to them in order to decide or to contribute towards deciding the question under Section 9 happens to reflect the purpose for which we are putting the Dutch judgments. But I have to say we are slightly baffled as to why Milan Friend suggests that can't be done. The requirements for under Section 31 are satisfied. The judge below decided as much, and there is no appeal against that finding. So your lordships are, with respect, left in a world in which that is the position. Ground 4, special circumstances. Again, we're not really sure whether there is any separate life in this point at all. We accept as a matter of principle that if there are special circumstances, the court can disapply or can choose not to give effect to an issue estoppel. There is no dispute that that is the law. There was no dispute in the court below that that is the law, and the judge below applied the law in paragraphs 114 to 120 of her judgment. There is nothing in the grounds of appeal or in my learned friend's skeleton to suggest that the decision that she took was somehow outside the bounds within which reasonable disagreement can be reached. She applied the right legal test. She reached what is essentially an evaluative judgment, and it can't be said that the decision she took was plainly wrong in appellate terms. So she applies the law, she applies it in a way that can't be impugned. There is nothing, with respect, there is nothing more that can be said in this court in reliance on special circumstances. I just have a moment, because there was some stuff in the original skeleton that my learned friend hasn't touched on. I don't know that we need to dwell on it. Yeah, just to clarify a couple of the points that my learned friend dealt with towards the end of his oral argument. He mentioned the fraud in the arbitration issue. That, as my Lord Justice Lewison suggested, we would absolutely agree that that cannot go to jurisdiction, and indeed that is what the judge at first instance decided, and there is no appeal against that part of her finding. She decided that the jurisdictional issues that are raised here are identical with the jurisdictional issues that have been decided conclusively and finally in the Dutch judgments. As my Lord Justice Lewison pointed out, the point that has been referred to the Amsterdam Court of Appeal, which it has decided and is now going on appeal to the Dutch Supreme Court by way of cassation, on the allegation of fraud in the arbitration, cannot go to jurisdiction. It goes to the way in which the arbitration was conducted. And indeed, the fact that the Amsterdam Court of Appeal was not dealing with any question of jurisdiction is demonstrated by the judgment itself, which doesn't discuss jurisdiction because it wasn't seized of that matter. Your Lordships have that judgment. I'm not going to take you through it to prove a negative, but it's in the supplemental bundle at tab 10, at page 157. The other point my learned friend flirted with is that there is a real possibility of a reference to the CJEU on the interpretation of the Energy Charter Treaty. There isn't. Mrs. Justice Cockerill made a ruling that the Amsterdam Court of Appeal could not, as a matter of jurisdiction, make a reference, because the issue that had been referred to them was not an issue that touched on the interpretation of the treaty, and that is paragraphs 95 to 111 of her judgment. And those haven't been appealed. So it simply isn't open to Russia now to suggest that there are any points in the Dutch proceedings that are capable of going to jurisdiction which haven't been closed down. The final point is ground 5. The suggestion is that because the issue in respect of which we are seeking to invoke an issue estoppel involves a question of treaty interpretation, that somehow militates against giving effect to an issue estoppel. With respect, there is absolutely nothing in that argument. The building blocks that Russia tries using for this simply don't prove the point that they need. They say that an international treaty can only have one correct meaning, which is true, but it doesn't get us anywhere. It says that decisions from the courts of other states' parties can be considered but are not binding, which again is true but irrelevant. And they therefore, with a leap of illogic, say that the English court therefore cannot give effect to an issue estoppel based on the Dutch judgments. The idea that English courts can take into account but are not bound by the decisions of other courts in relation to an international treaty to which both judicial systems are bound, would have some relevance if what had happened is a foreign court had given a ruling on the interpretation of the ECT in other proceedings between other parties, and the English court then had to make its own mind up about that. But that is simply not this case. We're dealing with a situation where the Dutch courts themselves have reached a final and conclusive ruling as between these parties. The English court is being asked to give issue estoppel effect to that foreign judgment consistently with the statutory regime here. The suggestion that somehow the status of the issue as being to do with the interpretation of an international treaty therefore means that the English court shouldn't give issue estoppel is with respect, another non sequitur. So essentially, I think the wrap-up is that your lordships have obviously had the opportunity of doing the pre-reading. The arguments that have been advanced essentially consist, as we said at the very beginning, of a repeated assertion and reliance on the importance of state immunity, but without identifying any tangible basis, either in the case law or in the legislation itself, to support the proposition for which my learned friend contends. And there is, we would submit, absolutely no basis upon which the judgment below can be impugned. Can I just briefly take instructions as to whether there's anything else? I'm very grateful.
Thank you very much, Mr. Craig. Mr. Flynn, do you wish to reply?
I do have a few points, my
Yes,
lord,
of course.
but really the main point is that I just want to make sure that the court is happy and has no concerns.
Happy with?
With anything that's been said. So if you do, I'm very happy to address those. But in a sense, I'm coming back and saying I'm going to try and avoid repeating what I said.
I hope so.
I'm sure your lordship will tell me if I am. Can I just take it in stages as to what was said against me? The first point was we propose a bright line test. We do propose a bright line test. What is said is, I think my learned friend says, well, the case can be fact sensitive. Now, that's not my understanding how the case was put below by them when one reads the judgment, that it was fact sensitive. It was just we were simply wrong and that they could rely on the findings in the award. And it's very difficult in my submission to see how you can have anything other than a bright line test in these circumstances. And it's not how the cases are put, for example, on the scope of jurisdiction in Ahmed and Aziz. It is a bright line test. The judgments that I took you to, they expressed themselves in very broad terms, and rightly so in my submission. There were a couple of, I wouldn't say they were criticisms exactly, but they said that I had conceded some things and that somehow affected the merits of our case. I had said that an English judgment, where the English court does what we say it should do, which is to fully determine the facts, would give rise to an issue estoppel. I don't think that's really saying very much, because obviously we're not suggesting that that any state get a judgment from one judge, not like it, and then say, well, I'm going to start again and have another one until I get the result I want. Of course that would be the position. In a sense, it's common sense. If the court fully and properly determines this issue of state immunity without reference to issue estoppel, then that will mean that that decision then goes through the normal process of appeal and so on, and that will result in a decision. The state can't just endlessly ask the court to keep answering the same question. But in a sense, that doesn't take it any further at all. The English court will have complied with its obligation to determine the issue under the State Immunity Act, and it will have complied with its obligation as a matter of international law on the UK. But that doesn't answer the question. You can't expand that by reference to estoppel. It has to be an autonomous decision. The other point made was compliance with process in the Zhongshan case. Now, again, we accept that the state has to comply with the rules of the court. The problems that may give rise to that, or Justice Zacaroli identified one, what happens if the court thinks that there is immunity and the exceptions don't apply, but the state doesn't take part? That might give rise to difficulties in due course. But the difference is that the court, if it does as we say it should do, it gives the state the opportunity to put that's what's the difference in principle, which is the state can then do so. If the state, as in Zhongshan, wrongly doesn't comply with time limits or whatever, the court can take, the consequences will follow from that. But it is different. The court is giving the state the opportunity to put its case. The alleged non sequitur, this was what was put against me. What is said is that we are saying state immunity is important and therefore issue estoppel doesn't apply. Now, that is not the way we put our case. We've put our case on three separate grounds. The first ground is, well, I won't go over it again, but the point is most obviously answered by Ahmed and Aziz. It is clear, it's obvious that in State Section 1 it doesn't say, in terms, you cannot rely on issue estoppel. But the cases you've seen and the principles I've identified and the submissions I've made in my submission show that that is the conclusion to be reached. It's not simply that it's important, it's that the court has an important obligation which is different to the other types of obligations that you find in litigation. And so that's the first point. Clearly, it's not as clear-cut as having it within the section itself, but it clearly follows from that. But the second point, Ahmed and Aziz, I think is much, much clearer, because that's a very analogous situation. The court expresses itself in broad terms, estoppel is not available. You can't expand jurisdiction by reference to issue estoppel. And it's not a matter of creating a new exception. It's about applying the exceptions that are there. You can't do that.
Ahmed and Aziz, that was the King of Saudi, the Prince of Saudi Arabia. That wasn't an issue estoppel case.
No, Aziz and Ahmed, I'm saying.
Oh, right.
Aziz and Ahmed, the case is on in the
employment cases.
Yeah, and they're expressed in very broad terms, and rightly so in my submission. And it isn't. The answer isn't to say, well, then the respondent is not asking for a new exception. It's asking for Section 9, but you can't answer Section 9 by reference to an issue estoppel. Diag and Dell, I won't say anything. I think about those. I mean, I've made my submission on that. They really don't help you at all. They're different cases in a different context. Deutsche Telekom, again, I'd be repeating myself, which is that the issue before your lordships is not addressed in that case at all. And the most that can be said against me is the prejudicial point, well, he had Lord Mance in that case, he knows a thing or two about this area, why didn't he spot it? It doesn't really take you very far. Steamship, to be fair, what my learned friend about said, that he accepted in terms, his point didn't take you very far, but Mr. Justice Hamlin, sitting at first instance, as he then was, applied normal principles of law. Well, so be it. This is about whether or not issue estoppel applies to Section 1 of the State Immunity Act. It's a very different question. Yes, then the other point, the only other point I want to deal with was Argentina. He says so Argentina and Section 31. And effectively, it comes back to the same point, because my learned friend said in terms he can rely upon an issue estoppel from the judgment. And he said later on a slightly different point, the point I think raised by my Lord Justice Lewison, which is about Mills and Cooper, he said it's an estoppel, and the effect of the estoppel is that you can only look at the judgment. So you can't have evidence, you can't have anything else, you just look at the judgment. Now, I'll explain why I'm not sure that's correct, but even if it were correct, it still doesn't answer our point, which is that you're tying one arm behind the back of the state. And even if he got a judgment, as he says he would have been entitled to, it doesn't help him, because he's asking the court to look at that judgment for the purposes of using the building blocks to create an issue estoppel, which is what you can't do. And my Lord, I think my Lord Justice Mayo said at one point, it would be unusual not to give effect to recognition to a judgment when it has been recognised. It would be unusual to do that. In a sense, I accept that. Ordinarily, one would be able to rely on that, but that doesn't meet the point here, which is our point is under Section 1 of the State Immunity Act, my known friend wants to look at that.
I said that it would be odd to have an issue estoppel if the judgment was not entitled to recognition.
Yes, I'm putting it the other way around. Yes, I accept that. But again, it doesn't answer the point, and 31 doesn't get him anywhere, because he's still asking this court, as he did in terms, to use that judgment for the purpose of creating an issue estoppel under Section 1. So it doesn't help. Yes, sorry, the only other point I was going to make, which is the Mills and Cooper point that my Lord made about what Lord Diplock meant. And I think what I would say about that is, we do say in our submissions that issue estoppel effectively means there's no issue. and there's no determination. It's a way of sidestepping a determination. In a way, that is semantics. And I can live with my learned friend's formulation that you can't look at anything beyond the judgment. That is impermissible. So even if he's right about that, it's impermissible. The oddity about what Lord Diplock said is, in my submission, either there was an issue before the court or there is no issue, and the estoppel just means you can't put in evidence in response to the issue. But that would make issue estoppel a rule of evidence. And what Lord Diplock said just before that passage, he says issue estoppel is not a rule of evidence. So it would be quite odd, I think, if he were turning it into a rule of evidence. I'm not sure it takes anyone any further, my lord, because, as I say, it's semantics. Our point is one of principle. And I can live with my learned friend's formulation that he wants to look at the judgment, and you can only look at the judgment. That process is impermissible. Well, so I think that was all I actually wanted to say in reply, unless your lordships had any questions.
Thank you very much, Mr. Flynn. Well, you've raised a very interesting and novel point, on which the one point of agreement is there's no authority. So we will go away and consider it. We will issue a draft judgment in due course. That is your opportunity to correct our grammar and English, but not our reasoning. And we would hope that in the light of the draft judgment, you will be able to agree an order. When you are taking instructions about the form of order, please remember there is an embargo on the draft judgment, which must be strictly complied with. And if you can't agree a form of order, please make short written submissions. We will make the form of order we think is appropriate in the light of the submissions. The future hand down will be done remotely, so there's no need for further attendance.
Okay.
Thank you both very much, and congratulations for finishing well within the day.
All rise, please.